Welcome to the Respectful Divorce Podcast. If you're considering divorce, it's important to know that you have options for how you divorce. On the Respectful Divorce Podcast, we explore those options and provide advice from divorce professionals. I'm your host, Tim Crouch, and today we're talking with two members of Collaborative Divorce Denton County, Darcy Loveless and Camille Milner, both of whom are collaborative divorce attorneys. Camille and I both serve as hosts of this podcast, and she is my better half. But today I want to talk to them about collaborative divorce here in North Texas and specifically in Denton County.
Thank you, Tim.
So let's begin with a really easy or maybe not easy question. How or why did you become family law attorneys? Darcy, why don't you start?
My father, who's our senior attorney at our firm, has been board certified in family law for 50 years. So when I started to work in the legal profession, I joined his firm and became a family lawyer. The collaborative movement has spoken to me because it's become apparent that in the context of family law, we have the capacity to do great damage. And this is a way to help people get through this process and reform their family without that damage, because I didn't really join family law with an eye towards causing damage to families.
Now, did you know when you went to law school you'd go into family law?
I think by the time that I was in law school, I did know that I would come back and practice with my dad.
Yeah. And Camille, how did you end up in family law?
Well, I didn't start in family law. I took only one family law course in law school, and I think that was just because one was required. And I didn't practice family law for nearly 10 years after I got out. Maybe it was closer to 8. But there seemed to be a need for women in family law because women that were in divorces wanted a woman because they seemed to think women had more empathy about what they were going through, and men wanted women in family law to represent them because they felt like if they go before a judge or jury, it lessened the two men beating up on the little woman. But what was the real impetus was Darcy's dad was my mentor, and he urged me to go into family law about that time. So it was really, Curtis has been a great influence on all of us and certainly both of us.
So, but what appealed to you about family law once you started practicing it?
Well, I think the fact that my grandparents got a divorce when I was about 6, and they were, because I stayed with them a lot of the time, they were very mindful of doing it in a way that wouldn't harm me. That way, before there was anything like collaborative or mediation, I had a model of people that did it compassionately because they wanted to take care of the extended family. And they stayed friends and talked nearly every week till he died. So that was 30 years of remaining friends. And so they had a model of amicable divorce that I grew up in. And so that seemed what was the norm to me rather than the litigation process.
So how did you actually move toward collaborative? How did you become involved with collaborative?
As I say, litigation never seemed like a good fit for family dissolutions or custody cases to me. It gave me an internal dissonance. There was just something about it that didn't feel right. And while there are cases that must go through litigation and through the court system, when collaborative came on the scene, I thought I have found my home. And this is like a kid glove cut with a pattern and sewn just for me. And that was 25 years ago, almost 26 years ago. And that has been my home ever since.
Now, Darcy, your father really hasn't made that transition to collaborative. So how did you begin to make that transition?
I made that transition back, I think it is 25 or 6 years ago now, in about 2000. There was a collaborative training that came to Texas, to Houston, and that was the first one that I think any of us in Texas went to. And most of the board certified lawyers in town hopped a plane, flew down, went to the training. And sort of like Camille said, there's a fit there for a large subset of people that can make this a better process. It's a kinder process. It does a lot of things for the family that litigation cannot do. And so I brought that back to my practice and have worked to become the collaborative part of our team. We have an associate that's also trained now. Curtis has headed up the litigation section of our firm and kind of continues to do that today. All of us can litigate. In fact, although Camille prefers the collaborative process when she can, I've recently heard a judge say that they heard her do the best cross-examination that they had ever heard in their time sitting on the bench. So I will say in Denton County, most or all of us in the collaborative process also can be litigators when necessary.
It's a different mindset, though, isn't it? To practice collaboratively from how you have to practice in the courtroom?
It is a different mindset. In collaborative, everyone in the process is committing to share certain information and to make it available and to have all of the pieces of the puzzle in front of them when they are making decisions. In litigation, sometimes people try to hide those pieces of the puzzle and make it more difficult or try to get away with things that you're not supposed to get away with in the collaborative process. In the collaborative process, people are making their own decisions about what is best for their family instead of relying on the judge who's working within the legislature's framework to tell them what their family's going to do. And so there are some big differences.
So, Camille, how does this process work?
The collaborative process is based fundamentally on a different approach. The litigation approach is position-based. Each side has their own goals and interests, and the rules of the game in litigation are you win by saying as much bad stuff about the other side, basically, as you can. And it is a zero-sum game. People come out of it often wounded and often with relationships that will never be healed. And it is a generational damage. For generations, families are impacted by that. Collaborative, on the other hand, is what is called interest-based negotiation. And part of the work that Darcy and I do with clients at the very beginning is we privately meet with our clients. We still have attorney-client privilege, and we still have strategies that we don't share with everybody. It's not a completely open book, but we explore with our client if they are there with goodwill and if they are capable of working in the interest-based negotiation process, which is we work with them to discern what their goals and interests are. And we go over that at every meeting. And it's usually they don't want their children to be damaged. They don't want their extended family and friendships to be damaged. They don't want either one of them to be financially destitute. And they want a process that is efficient and private. And so we work with those clients to ferret out if this is what they would like and this is what they would like together. And then metaphorically, we all have a box of Kleenexes in the middle of our conference tables. And metaphorically, instead of fighting each other and instead of on TV where the lawyers are on one side or the lawyer and their client is on one side of the table and the other lawyer and the other client's on the other side of the table, which is more of a war mentality, the clients sit on one side and the lawyers sit on the other side. And at the ends of the table are our neutral professionals, a CPA or a financial planner, and then a mental health professional at the other end of the table who serves as the communications coach. And so when I say metaphorically, we are like a set of 6 engineers sitting around the table trying to figure out the best way to solve this issue and problem.
Talk a little more about those neutrals, the financial professional and the mental health professional, and how they work in the process.
Well, the mental health professionals do not do therapy. They leave that therapy job at the door. In other words, they're not trying to fix these people, but they are experts in communication and in developing parenting plans for the parents when they have children to cover things like rights and duties, possession periods, parenting time periods, and how to co-parent. And they sometimes even manage the lawyers in the room with their communication skills. It's not unusual for the lawyers to need a little counseling from the mental health professionals on how to better communicate. At the other end of the table is the CPA or financial planner, and they help each of the parties individually work on their budgets so that they will launch and go forward successfully. And they help them do an inventory with all the information Darcy talked about that is transparent, meaning all the information that would normally be exchanged through something called discovery in the litigation process. This is much less expensive, much more efficient, and everyone basically pulls the curtain back and lays all the financial liabilities and assets on the table. The CPA or financial planner pulls them all together in a joint inventory. And so it is enabling the couple to see everything without mystery and to figure out the best solution for everybody going forward. You've used the term, Tim, that a rising tide floats all boats. And that really is true in the collaborative process, because what the studies have shown is that if we work through the interest-based negotiation process, that both clients end up doing better.
Darcy, the financial professional, it's always struck me that maybe the hardest question or the most anxiety comes from, am I going to be all right financially? The financial professional oftentimes is the person who gets people to the point that they feel like they'll be okay, right?
Yes, they are. And that person can be invaluable, especially if one side has questions about whether they will be able to manage a budget. In litigation, we often don't look to how people are going to pay their expenses after a divorce. We simply look at assets and liabilities and divide those things up. In the collaborative process, we are looking more towards, as Camille said, interest-based negotiation. And one of the interests people almost always have is to be able to comfortably pay their monthly expenses and later move into retirement in a way where they can stop working when they are ready to stop working. Ensuring that we do not divide their property in a way that prohibits that where it's possible is very important. And this process allows us to focus on that. The financial professional will gather all of that information. The financial professional can talk with us about the tax implications of some of the property division. And the financial professional will sit with our clients and help them make a post-divorce budget so they can realistically see what they need each month and whether a particular property division will provide for those needs. Each party can still hire other planners to help them if necessary. And there have been some cases where that was very helpful for someone to do some projections about, for instance, what an investment might make over the years and how long it would last. And so people certainly can do that. But the neutral financial professional is the one that really coordinates it all, gets the ball rolling, and goes through those numbers with people in a way that they can feel comfortable.
How have you seen the collaborative process make a difference in some of your clients' lives versus those who went through litigation?
I have most recently seen a difference in the financial arena with a family where one person had been the primary working spouse and the other had been a primary stay-at-home spouse. And with the divorce coming, the one that had been a stay-at-home spouse had some challenges to full-time employment at that stage of their life that were probably going to preclude a full-time job, certainly preclude a full-time job that earned anything close to what the working spouse was making. This process with the financial professional, and in that case, they did hire a separate planner as well, helped her have the comfort levels she needed to be able to step away, make some business decisions, and finalize the case. Even though the financial professional was not doing the mental health professional's work, that process helped on the mental health side, because when someone is stepping out into something that they did not anticipate, there can be a lot of fear that creates distress, creates paralyzation where they are having a hard time moving through the process. And the financial person being able to help stop those fears in their tracks and show hard numbers and say, this is what you can do, was really sort of the thing over and above what the mental health professional was able to do with that couple to put the fear enough to the side to finalize. I've also seen people with some issues with children that instead of litigating these cases so that their children feel unhappy every time they see each parent, or so that their children feel worried that they will always say, something to mom or something to dad that winds it back to the judge. This process is confidential. There is no judge hearing those things. I think it takes the stress off the children in that regard. And we are trying to train parents, sometimes successfully, so that when issues come up about their children later, they have some tools to talk them through instead of jumping back to court. And we think that helps the children both emotionally and financially, because their parents are hopefully not spending lots of money back in litigation over the years.
Yeah. Camille?
To Darcy's point about helping the non-outside the home working spouse, this is true not just for them, but for everybody in Collaborative. Not only are we transparent with all the financial information, but part of our job, and what I think we do a really good job of, is if there is one client that is less financially educated on finances generally, or what the parties own and owe, with the financial professional, we are able to educate them and get them to the point where they say, I have enough information, I feel secure in making an informed decision. And that makes all the difference, both with the finances and with the parenting plan, because by going through what the rights and duties are and how to allocate those and what the consequences of those might look like, just going through scenarios, both on the finances, on the children's issues, these people are able to become empowered in a way that they cannot get in the litigation situation, because in court, a person comes out and makes all the decisions for you. This collaborative process enables the clients to synthesize an agreement that they create and they feel empowered by, so it seems to be durable and work more effectively. Very, very few, if any, of our cases that work through the collaborative process ever have to go back to court.
In that regard, I recently had a chance to look back through the collaborative cases that I have engaged in since 2001. And although there was a subset that had gone back over the years for regular child support modifications, which typically happens as, younger children become older and time passes, I only identified 2 cases that we had finished in the collaborative process that had gone off later into emergency litigation that required significant court intervention. And I don't know how that anecdotally would compare to everyone else's results across the state, but I thought that was a really positive sign for the process.
And in litigation, that's not unusual to have to keep coming back over and over again, right?
Correct. In litigation, often people litigate every 2 or 3 years at a fairly significant expense to themselves. And I will say some of those people have to be in litigation because they are not in a place where either side can make decisions with the other. And there is no choice but for the judge to make those decisions. And for that subset of people, repeated litigation is, an unfortunate reality. But studies show that repeated litigation is one of the worst things that parents can put their children through. And so for the people that do not have to engage in that process, I hope that they find this one as a good alternative.
Yeah. So this is the Respectful Divorce podcast. When we talk about respect in divorce, what does that mean, Camille?
Coming to the table with goodwill. I had a client once years ago that brought in the book, The Art of War, and he said, "We will take no prisoners." Sometimes litigation feels like that to the clients. I had a client one time that ended up having to go through litigation, and in the midst of a 5-day jury trial, we went out in the conference room outside the courtroom, and he said, "Promise me that you'll tell all your clients going forward, never do this. There is never a justification for it to always go with the collaborative process." And as Darcy said, that's not realistic for everybody, but it's realistic for most. And the sad thing, and the thing that we are challenged by, is that people that come into the collaborative process are looking for privacy. And these are not people that are going to be like the Kardashians and go out on their social media and tell everybody about their life and their experience. They want privacy, so they don't tell people as much about it because what we're able to give them is privacy. And that means we have a special challenge on helping other people. And I wish it could be more social media driven, but I wish that there were some way that we could help more people know about it, because more people deserve to enjoy the attributes of this process than are able to.
So in the collaborative process, Darcy, what does respect do? How does that impact the process?
I believe the expectation of respect impacts the process in the way that we speak to each other in the meetings, and therefore the way the clients can approach their issues and their problems. I think that it's very helpful there. I think that respect also means in this process that when you sign your participation agreement, because there is an agreement as to what each of us will do in the process, that you are signing it in good faith and you will do the things that you say you're going to do, which is discuss things based on interests, to provide all of the documentation requested of you, to do some things like that. And it helps give a framework for the process where we can work through it without all of the emotion that sometimes colors decisions in litigation. And that's not to say that these people are not emotional. Divorce is one of the most painful things people can do, and there are emotions. And it's not to say that just because there's respect in the process, that there is always trust in the process, because often people have come to the decision to divorce because in one way or another, someone has breached the trust of the marriage. As Camille mentioned, there are a subset of people for whom the process is never appropriate, and perhaps the person that brings the art of war to the consult would be one of them. We have careful screening in the event there is a significant imbalance of power in the relationship that would be coercive, or in the event of family violence. And that would be a very case-by-case decision as to whether a case was suitable for the process or not.
And ultimately, I guess if you've gone through this process and you've been respectful, it means that you have a better co-parenting family relationship after the divorce is over. Is that right?
I think so. Darcy and two of our mental health professionals in our local group have written a book called Meeting Your Interests. It's about the collaborative process and other methods for dispute resolution. It's available on Amazon. And there's a quote in there from some clients that I was able to be a part of their collaborative case. And they left hand in hand and went to have breakfast that day. And what they said was, "You have helped us return to our friendship, learn how to be co-parents, and our children will be the beneficiaries of that." And there are emotions in the room. And the mental health professionals, the difference, I would say, is that instead of the emotions getting out of control and spewing out the sides and damaging the relationship further, somehow the mental health professionals have the techniques and the skills to keep it contained and help everybody work through the emotions so that they get on the other side with a working relationship that is good for them and good for their children. There's a common misconception that, like you say, it's a kumbaya, and we do very, very hard work. We work through very difficult emotions, very difficult issues, but we do it with some level of compassion, very much a level of respect. And as I said, they come out on the other side with a working relationship typically that enables their children to be in a better place and them to be in a better place financially and emotionally than if they did it with any other process.
So I want to talk in a moment about Collaborative Divorce Denton County, but you all are also members of Collaborative Divorce Texas, and you are both credentialed. Camille, you're a master credentialed, and Darcy, you are newly credentialed by Collaborative Divorce Texas. Congratulations. What does credentialing mean?
Well, credentialing in this process means that you have done, depending on your level of credentialing, a certain number of cases in the process. They are reviewing the cases to ensure that you actually did the cases. They check back with any neutrals that you had on the cases or with attorneys that participated in the cases. And if the credentialing committee finds that you meet all of the requirements, both for your caseload and some significant requirements for continuing education in this area, then you can have a designation as a credentialed collaborative professional, or in Camille's case, a master credentialed collaborative professional. And it is in some ways the equivalent of board certification in other specialty areas where you have to take an exam and meet certain education and litigation requirements to achieve certification in those areas. This is the equivalent of that in the collaborative arena. And it is something that means a credentialed person has had significant practice in the area.
Which means significant skills, right?
Significant skills, gone through the fire of cases where, for example, Darcy and I have had some very tense moments in cases because there are times that we have to discuss very charged issues, but the people that are involved in the collaborative process have a level of trust between the professionals that enables them to help the clients work through those very difficult issues. And if not a complete resolution of them, at least come to a consensus on how to move forward.
Now, you're both members of Collaborative Divorce Denton County. What is that organization, Camille?
Well, it's an organization that Mark Lewis, one of our collaborative lawyers here in Denton, started about 2000. There are collaborative lawyers, collaborative professionals all over the world. Texas is one of the leaders in that. I like to think that Denton is one of the leaders in Texas because we started early on with a commitment to the multidisciplinary approach. There were practice groups, and there are still practice groups, I think, around that only allow lawyers in. We recognized early on, thanks to the wisdom and leadership of Mark Lewis, to understand the value that the neutral professionals brought to the meetings and to what we do as a group. So by meeting every month and having an annual retreat, we are able to exchange ideas. We're able to talk about scenarios that we've dealt with so that each of us can benefit and not have to recreate the wheel or reinvent the wheel every time we hit a bump that's a difficult issue. I think it also helps us have a bond between us that sometimes one of us may have to do something that in litigation, it might blow something up, but in collaborative, we might have to go into an issue and it be tense, but we have a trust amongst us as professionals that we know if the other side is bringing something up and it has to be managed, we trust them, and then we can work through it together, as difficult as it may be.
And one of the things with that is there's a website where somebody can go to find trained collaborative professionals in Denton County, right?
That's correct.
Yes.
And we will put a link to that website in the show notes. If somebody wants to get in touch with either one of you, what's the best way to do that, Darcy?
We have a website at loveless.law, and that allows people to submit inquiries to our website for a callback. We also have our office phone number at 940-387-3776, and that allows a message to be left at any time, 24 hours a day, that will be returned to address anyone's inquiry.
And Camille, how about you?
My email is camille@milner-law.com. My website is milner-law.com, and my phone number is 940-383-2674.
All right, we're going to put all that information and links in the show notes. Thank you both for joining us today on the Respectful Divorce Podcast.
Thank you, Tim.
This important programming note, Divorce with Respect Week is March 3rd through 9th. During Divorce with Respect Week, you can talk with lawyers, divorce coaches, divorce financial experts for free to learn more about the divorce process and your options. Simply go to divorcewithrespectweek.com to find professionals near you. That's divorcewithrespectweek.com. I'm Tim Crouch reminding you that collaborative divorce is a better way to untie the knots.